Hi, I'm Angela Princeville here today talking to you about pets and family law. And often we get these questions from separating couples who have a pet. Both parties clearly love the pet, and there's always a concern about what happens with this pet now that we've separated. Unfortunately, in family law, pets are considered to be property, and by that, property follows ownership, except you could show otherwise. So usually what the courts would be looking at is, well, who bought the pet, and whoever, I mean, where that's a clear answer, then usually that's the owner of the pet, and that's the person who gets to keep it. And I know that might sound outrageous to a lot of people, a lot of pet lovers. um, Being in the relationship, clearly both parties have gotten attached to this pet, and sometimes people expect the courts to create visitation arrangements for pets just as they do children. Unfortunately, the courts have declined time and again to do this. They would not, fashion a visitation arrangement. If the other party consents to it clearly, then that's fine. And it may not probably not be incorporated in a court order, but if it's a separation agreement setting, then that's something that the parties could include in their agreement. But absent that consent, there's nothing the courts can do to make the other party facilitate visitations between the pet and the other partner that's separating and would not be keeping the pet. So short answer is, well, pets and family law, the courts don't really deal with it except looking at the pet as property and just deciding whose property it is, and where the pet goes. So I hope that helps, even though I know that's not what a lot of people were hoping to hear, but that's the position of the law at this point in Canada.